Welcome to today's program titled Employee Off-Duty Conduct, Considerations and Strategies for Employers. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on your screen. If we are unable to answer your question during the program, we will follow up with you after the webinar. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down, as it will not be reread and it is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw, LLP, for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Scott Mallory. Scott, please go ahead.
Hello, everybody, and welcome to our presentation today on an employer's ability to regulate off-duty conduct, which is not only salient in today's environment, but clearly a very interesting topic, just given the pure breadth of the number of registrants that we have for this particular issue. Joining me today will be Don Soloway, from a partner in our Boston office, who will be speaking to sort of Title VII restrictions on employers' abilities in this space. And then we'll also hear from Sam Schwartz-Finwick, a partner in our Chicago office, who will be speaking to sort of the NLRA and the NLRB's involvement in this specific issue. On the next slide, please, will be a roadmap of where we're going to be going today. I'll be discussing sort of the broad panoply or diverse amount of state law statutes there are out there that regulate an employer's ability to regulate its employees' off-duty conduct. We'll speak to the NLRB's approach to off-duty conduct and how certain concerted activity outside of the workplace can violate the NLRA. There we go. And then again, we'll get back to Dawn for Title VII considerations. And then we have a couple of hypothetical scenarios and questions. For those lawyers here, it'll be like going back to law school, except for that we won't be able to call on you in a Socratic method. Next slide, please. And this is my portion of this fun overview, so could we go to the next slide, please? The starting point of any analysis as it relates to an employer's ability to regulate off-duty conduct is to kind of get back to the beginning and realize that in the United States of America, this is an at-will employment system, except for Montana, surprisingly, which is the one state, the one jurisdiction that does not have an at-will system. Basically, at-will meaning that unless there is some statute, an employer has the ability to terminate or impose any kind of adverse employment action on an employee that it would like to based on any kind of business reason. But as is noted, every single state has some kind of, anti-discrimination law in the first instance, right? A ton were passed at the same time as the Civil Rights Act. You can't terminate or impose an adverse action upon an employee because of their race. Those statutes have now been amended to include sexual orientation, et cetera, et cetera. But this presentation in and of itself is just impossible to go through every state's anti-discrimination laws, especially because, as you'll see, every one of those anti-discrimination laws is drafted completely different, and the way that the courts in each of those states have interpreted those laws make them even more different. As a general sort of conclusion, right, based on all the research that I've done and a ton of other lawyers in this space that I've worked with have done, is that a lot of employers would probably be surprised to find that their ability to sort of regulate off-duty conduct is actually quite discretionary, and there is a broader ability to regulate off-duty conduct, at least in the space of state laws prohibiting it. Even in some of the more conservative justice jurisdictions, and especially, right, where it can be related back to some kind of a business necessity. Next slide, please. At common law, again, we're at sort of an at-will system, right? But there were a couple of developments through the courts that happened that would allow, that would prevent an employer from certain conduct that would invade the privacy of its employees, right? So typically, this has been so this has been really narrowly construed. It is to an employer, asking someone about their sexual orientation or delving into other really personal issues. Like, for example, one Illinois court found that to succeed in adequately pleading and proving a cause and action for unreasonable intrusion upon seclusion, which would be privacy, they would have to show that the intrusion was not only offensive, but highly offensive to a reasonable person in a similar situation. So broadly speaking, the tort of invasion of privacy as it comes to the employer-employee relationship is very difficult to prove. Similarly, almost every jurisdiction has a wrongful termination and violation of public policy tort. This tort also has been construed as being extremely narrow, right? Public policy generally could be read broadly to be sort of anything that someone thinks would be a normative reason that the government would be interested in precluding, but that's really not it. It really has been things like jury service or participating in voting, things like that you can't wrongfully discharge someone for voting, right? That would be it. Or the other time that a public policy has been established is when there's a statute. So there would have to be a statute for a public policy wrongful discharge tort. So to get into the statutes, we'll go to the next slide. Almost every state has a bunch of statutes to protect off-duty tobacco use or certain product use or alcohol use. The most latest and greatest is cannabis use. Just this last legislative session, Governor Newsom signed a bill that makes it very illegal. It's very protective of employees' right to use cannabis off of work premises, outside of work. The employer cannot discipline an employee for the use of cannabis off work. And now most jurisdictions, there are now 12 jurisdictions that have passed similar laws. And I would expect that to continue the same way that legalization of cannabis has continued throughout all the other jurisdictions. Next slide, please. Okay, probably what everybody's most interested in, right, is this, what statutes are there that prevent an employer from disciplining an employee for actually engaging in speech or conduct off duty. Remember that employment is at will, and remember that the First Amendment does not apply to private institutions, right? So if a corporation has a policy that one would think is restrictive of the First Amendment, it's not actionable in court because it's a private company, right? Now, the protections for public employees, of course, are very different when it comes to speech. That being said, every state has a very, very different sort of structure for how they regulate off-duty conduct. For example, Arizona has no statute that regulates an employer's ability to regulate off-duty conduct, political speech, otherwise. No statute whatsoever. California, conversely, Its statute says that an employer may not discriminate against an employee or applicant because he or she engaged in lawful conduct during non-working hours away from the premises. California employers may not prevent an employee from participating in the political arena in any capacity, direct the political activities or affiliations of an employee, or threaten to discharge an employee for engaging in or refusing to engage in certain political activities. Now, within that, right, courts have defined what the political arena is, what political activities are, and it's different in every different jurisdiction, right? So now we go to Colorado, which says that an employer may not terminate an employee's employment based on an individual's lawful activities off the premises during non-working hours. Can't threaten to discharge employees because of their membership in or connection to a political party. Colorado courts have construed what being a member of a political party or political activities are different than what California courts have done it. So again, the point here is that you're going to have to do a decent amount of legal research based on your own jurisdiction before being able to provide a definitive answer as to whether a given hypothetical is something that an employer is allowed to do. Connecticut, which is really interesting, has an off-duty statute that says employers may not discriminate based on any exercise of rights guaranteed by the First Amendment, right? Which, remember when I said before that the First Amendment doesn't apply to private companies? Well, it does in Connecticut, which has the strongest First Amendment protections. But we'll see later. The courts in Connecticut have construed that statute to say it doesn't apply if the business can show that there is some kind of business necessity for regulating that specific kind of speech. And then there are a bunch of jurisdictions that have none, right? Delaware has no statute regulating off-duty conduct. The Washington, D.C., it depends. Employers may not discriminate against employees based on their political affiliation, but political affiliation in D.C. only means a state of belonging to or endorsing a political party. So it must be a pre-recognized political party. Political affiliation in California is broader. So again, apologize for repeating this, but it really does depend on which jurisdiction you're in. Typically, courts construing the various statutes have interpreted them to be narrower than the language of a dissect. Next statute, please, Kate, or next statute. Next slide. And again, it all comes back to this business necessity exception. There is no statute, even if the language seems that there would be a statute, that provides absolute protection to conduct outside of the workplace. Employers can impose adverse actions on employees who commit crimes outside of the workplace, right? You can't be an employee if you're also in jail. There's just no absolute protection to it. I would say that the strongest statutory, most absolute statutory language comes from California's labor code, which is just a plain prohibition of an employer regulating an employee's off-duty conduct. But in Augabauer versus Delta Design Incorporated, the court construing that strong statute still found that there was an exception when there is a business necessity. As such, it is imperative to research your own jurisdiction prior to making any definitive decision on whether or not an employer can regulate certain kinds of off-duty conduct. That is really it for this specific portion, but I'll talk about it later again when we get into the hypothetical. So I believe that, Sam, you're next.
Yeah, thank you. Thank you so much, Scott. And I know that if we can skip to the next slide, if that's okay. Yeah, and one more. All right, fabulous. So I know there's been a lot of chatter in the chat about the CLE code. I just want everyone to rest assured you missed nothing. We were just fronting that it's coming at the end. It's one of our hooks to make people stay on, even though our brilliant conversation is enough to want to keep you on till the end. But you missed nothing. It'll be coming probably in a little more than a half hour. So I am talking about the union context. And so one thing I wanted to flag is a lot of Scott's discussion was referencing at-will employment. It's important if you have a a bargain for portion of your workforce is entirely bargained, they likely have a different standard, which is they can only be fired for just cause. Obviously, that's a much harder standard if you want to issue discipline or terminate someone. So it's, it doesn't mean you can't do it. It's just more, it's a much higher burden to show. So for purposes of off-duty conduct, and this is relevant if you have a unionized workforce or not, because all employees are protected by the National Labor Relations Act with the right to engage in concerted activity. So what is protected concerted activity? So traditionally, it's meant 2 or more employees banding together with a purpose of trying to change something in their workforce. So for instance, let's band together and talk to management about making it warmer in the office in the winter, or making it, actually turning the air conditioning on in the summer. So it's a nicer work environment. That's a pretty easy example. However, over time, it has also become extended on some things where someone on their face is advocating on behalf of other people. For instance, saying, this is not a safe workplace, right? They're speaking as a party of one, but it's something that impacts the entire workplace. And more recent, depending on which board is in office, that can also be construed as protected concerted activity. Now, even if you're engaging in something that's indisputably concerted, let's go back to, kind of the innocuous, we want it to be a nice temperature when we're working. It's not protected to make your voice heard by starting a fire in the cafeteria in order to warm up the office, right? I mean, vandalism is not protected. So that's just one example. Trashing your employer as, their products are terrible, their products are subpar, things like that, as a way to get what you want, that's also not protected. You want to stick to the issues and do it in, using your better judgment, what is safe and lawful. So we can go to the next slide. So in the off-duty context, it's always been the case that, someone who is protesting about working conditions, they can do that off duty if they're protesting about the conditions at their workspace, right? There might be contractual limitations that prevent them from doing it while on shift, like a no strike or no lockout clause. But in terms of handbilling or picketing when it's not their shift, they certainly can do that because it's directly related to their work. What we've been seeing recently, though, is interest from the general counsel for the National Labor Relations Board, who is advocate, she litigates cases to extend, in her view, what should be protected rights. She's taken a much broader view, where even things that aren't directly related to employment, in her view, can be protected concerted activity. And we've seen a real surge of this since COVID. So there have been a number of charges filed in litigation regarding whether employees, and these cases have arisen at work, but the reasoning would also apply outside of work potentially, that employees wearing Black Lives Matter masks who were told to remove them have argued that that was impeding their protected concerted activity rights, because protesting, systemic racism is inherently something that's happening in the workplace, even if they're not necessarily tying that to any racist animus or racist behavior by management. So that's just one example. And the position of the general counsel is there doesn't need to be a connection. If you're pushing forward a social issue, depending on the social issue, if it ties into your work in some way, that can be enough. So an area we see a lot of postings is on social media. Now, an employer should not be policing their employees' social media. It can get into surveillance and a violation of privacy, all sorts of issues. But let's say an employee comes to you and says, hey, I'm friends with Joe on Facebook, and last night he posted something saying that he's excited to go joyriding and hit any Black person he sees on the road. Now, I can tell you that's a really horrible fact pattern I just presented. I had something very similar to that. A client raised that about 5 or 6 years ago, that exact fact pattern. Now, this employee was off-duty conduct, but it was also pretty much saying their plan, maybe in jest, maybe not, to engage in a hate crime. So that employee was terminated when that came to light, under the just cause standard of termination, because he was threatening to murder people, and the company clearly saw that violated its core values. And engaging in a hate crime, even if you do it with friends, is not protected concerted activity. Let's go to the next slide. So, and this is akin to a lot of what Scott was mentioning before, that when we're talking about off-duty conduct, that's not necessarily directly related to work, but it's more broadly related to labor and working conditions. You should not discipline your employees for engaging in those. I think we all remember probably like 10 or 15 years ago, there was a huge march for immigration rights that at its base, part of it was dealing with a practice by the Bush administration, so maybe it's even longer ago, by the Bush administration to do these spot raids on employers where they were asking for employment verification. And it was the position of the NLRB that was really a huge motivating factor in these protests that was tying it directly into workplaces. So that's an example of an off-duty protest that's really talking about universal job rights that all employees have. And so you should be really careful and definitely speak with legal counsel before you would consider disciplining individuals for participating in that type of conduct. And as we said before, I mean, that's more attenuated in that it's not directly related to work, but off-duty speech that directly pertains to work and is saying like, this is what's frustrating about my job, or this is what I wish I could change, or this is what me and my friends want to change. That's clearly or much more clearly covered within the scope of protected concerted activity. If we could go to the next slide. Yeah, so there's a good question about the difference between lawful versus unlawful conduct and being protected. Unlawful conduct is not protected, but that assumes that there's a bright line between what is lawful and what is not. And unfortunately, what we're seeing is a lot of times there's a lot of gray. And so, that hate crime example is pretty extreme, where it's clearly, talking about unlawful behavior, but a lot of other things are more on the fence, which is why you want to think through these issues and be confident in what you want the end result to be, but make sure you're talking with in-house or outside counsel or seasoned HR professionals to make sure that you're mitigating legal risk in your approach. So, as I mentioned, this is Jennifer Abruzzo she is Jennifer, but she's the general counsel for the NLRB. And she has been really outspoken in a multitude of issues, but one of them is to say that social justice and racial justice advocacy are protected concerted activity. Now, no court has endorsed her view, but it's an agenda that is being pushed very hard through litigation and in the issuance of complaints by the NLRB. And so it's something that's really important to keep an eye on, because these are things that on their face have nothing to do with working conditions. For instance, since October 7th, we've seen an upsurge in concerted activity by employees, both at work and off duty, challenging their company's positions towards Israel. You know, you're doing business with Israel, and we want you to cease and desist from doing that, and taking the position that that's protected concerted activity. That's one example, even though whatever the company's position is on Israel or the war in the Middle East, it's not going to affect working conditions at their location. But so that's just one example of how this this broadening by the general counsel, if it's adopted, could really hinder efforts by employers to keep the reins on speech in their workplaces and outside of it, and the scope of what unions feel they have the is within their purview to address. So one case I wanted to mention at the next slide, which just issued recently, was this Home Depot decision. There, again, it happened at work, but this fact pattern, if the general counsel's position was adopted, could readily apply outside of work. So it was an employee wore a Black Lives Matters, some Black Lives Matter paraphernalia on her apron, and spoke with coworkers and management about ongoing discrimination and harassment. The general counsel argued that just having that BLM paraphernalia on, that was sufficient in and of itself to be protected without any nexus to racial bias in the workplace. Because, you know, they were kind of saying this is a universal issue. You don't need to prove that connection. The board didn't go that far, at least on this case, because it found that here there was a logical connection between wearing that, you know, the BLM paraphernalia and a great deal of overt racial animus at work. But it's an argument that they're continuing to pursue. So I would say keep your eyes peeled on it, especially if there's a second Biden term. And with that, I want to turn it over to Don Soloway.
Thanks, Sam. So next slide, please. So now I'm going to talk about Title VII considerations, because when you're thinking about off-duty conduct, you want to be thinking not only about the state law framework that Scott covered and potential NLRA considerations, but also whether there are Title VII considerations to think about. The next slide, please. So we're going to kind of walk through some of the considerations that you want to think about in thinking about Title VII. One is, does the conduct impact the workplace? And so I'm not talking here about conduct that happens at the company sales meeting or at, you know, offsite or the holiday party or business trip. That's really, for all practical purposes, on-duty conduct, right? That is basically people being at work. I'm really talking about off-duty conduct, meaning something that happens outside of the workplace environment. But that conduct can still impact the workplace, particularly in today's world where people have phones and are maybe connected with coworkers on Facebook or other social media. And so it's important to think about, is there an effect on coworkers? I mean, oftentimes employers will hear about off-duty conduct through a coworker of the person engaging in the conduct. You'll want to think about, has it given rise to a complaint? So has somebody gone to their manager or to HR or to legal to complain about off-duty conduct? Does it have some sort of effect on the person's job duties? So let's say, for example, the employee engaged in the off-duty conduct is a recruiter for the company. Could that kind of social media or other off-duty conduct impact his or her ability to do their job? Does it damage the company reputation? And I think, you know, we've seen that sometimes off-duty conduct gets quickly picked up on Twitter or elsewhere and gets linked to the company very rapidly and disseminated very broadly. And so damage to the company reputation is something that can come into play as well. And then effect on customers, clients, investors, applicants, any other sort of stakeholder group might cause you to conclude that the conduct is impacting the workplace. In the next slide, we'll look at the question of whether the conduct implicates a protected classification. So is there something about the conduct that reflects animus or otherwise negatively affects a protected classification? So gender, race, religion, national origin, marital status, gender identity, age, veteran status. These are just some examples of the protected classifications that you might want to think about. So I saw a question in the chat about what if someone is engaged in white supremacist activity at an off-duty rally, right? That's a perfect example of where you would conclude that that conduct does implicate a protected classification. Next slide, please. You also want to think about, does the conduct violate a company policy? So even though it's conduct that happens outside of work, if it's something that is impacting people at work and impacting a protected classification, it may be something that would be prohibited under one of our policies. So that might be, for example, an anti-discrimination policy, an anti-harassment policy, a respect for others policy, EEO, or a DE&I policy. And here's a moment to kind of talk about making sure that your policies are updated for the current moment, because this is clearly a very polarized time. It's an election year, and these policies will be in a lot of ways your touchstone as to how to handle both off-duty and on-duty conduct that hits on some of these cultural flashpoints. And so, for example, if you don't have a respectful conduct policy, you might want to think about adding one in this moment. Next slide, please.
And just one point on that, in adding it, please make sure to check with Labor Council, because going back to our friend Jennifer Abruzzo, she feels that most civility policies violate the National Labor Relations Act because they require people to, in her view, people get to swear if they're angry with management. So make sure to check with Labor Council before you roll out a civility policy.
Yeah, that's a great point, Sam. And I think, we are able to offer clients kind of sometimes a range of different options for those policies that may reflect different levels of risk, depending on your risk tolerance. Another really important point when it comes to off-duty conduct is the duty to investigate. And this is really kind of the moment where you take a deep breath. If you become on notice of some sort of off-duty conduct that may potentially it be impacting the workplace, that you want to make sure that you actually have the facts. We know that there, in this moment, that there can be a lot of misinformation and disinformation online. There may be people who are motivated to put someone in a bad light. And videos and photos can be manipulated. And so you really want to make sure that at the base that you're working with the actual relevant facts. This is often when a client calls with one of these questions where we start of just, are we sure that this actually happened? Can you send us the actual post that you're talking about? What exactly are the words that the person said? And not making assumptions or listening to rumors or listening to potentially a coworker's account of what someone said on social media, actually looking at the messages themselves. Making sure that you're giving due process to the accused. So, potentially interviewing them and saying, look, we've become aware of this allegation about off-duty conduct. What is your point of view? And it's really important to remember, again, this is sort of in the Title VII space, that if you're on notice of a potential report of discrimination or harassment or retaliation, you may have a duty to investigate and to take prompt corrective action. So in addition to it just being a best practice to make sure you're working with the relevant facts, you may actually have a duty to investigate. And so that will give you a duty to make sure that you are reasonably thorough in your investigation, provide due process to the accused, make sure you get the full account from the complainant, interview any witnesses, look at any documents before you take any action. And with any investigation, you always want to decide at the outset whether you want that investigation to be privileged. So that's an important kind of practical point. Next slide, please. And I think both Scott and Sam alluded to this in one way or another, and there are some questions about this in the chat too. But one question is whether the conduct aligns with company values. That is obviously a very broad question and less defined than some of the statutes that we've been talking about, but it's still an important consideration. And it's not really a strict legal question, right? It's really more of a question for company leadership working with legal and HR and potentially other constituencies to decide whether this conduct is in alignment with company values. Those values might include DE&I principles, but they also might be broader, such as a particular corporate mission, and really will be unique to each employer. I saw a question in the chat about, to what extent can you rely on company values and can those be challenged? I think it's important that shouldn't be the whole question because it is a fairly undefined inquiry. But there certainly are places where it's appropriate to consider the company values and to look at, kind of what the evidence is of those values. So, for example, if the conduct is anti-LGBTQ, perhaps you can point to your DE&I policies and the fact that your company recognizes Pride Month and really kind of walks the walk in a lot of different ways, and that's going to help you to kind of show that whether the conduct is in alignment with company values. Next slide, please. And so if you determine that the off-duty conduct is substantiated, you've done your investigation and you've determined that you have a handle on what the facts are, and you elect to act on the conduct. So you've thought about the state law ramifications, the NLRA ramifications, the Title VII ramifications. Then it's time to determine what the appropriate consequence is. There's obviously a range of options with an at-will employee. And so you might think about whether, proportionally, whether it's appropriate to issue a verbal warning, a written warning. We find that a lot of clients, particularly if the conduct is not something that's sort of deemed a terminable offense, will lean into training or one-on-one coaching. So, if it's, let's say it's, one tweet that goes out, it's an isolated incident, maybe the language of the tweet is ambiguous. That might be a moment to do some one-on-one coaching and to talk to the employee about the fact that, when you put things out publicly on the internet, that they are seen by others and that they could be hurtful, that they could impact other protected classes, and that can be effective. Again, completely depends on the situation. Last chance agreements, as in some settings, can be effective of sort of this will never be tolerated again. And then obviously termination, is an option. Next slide, please. So here's where we're going to read the CLE code, which is SS, as in Seyfarth Shaw, 4571. So that is SS 4571. Next slide, please. So we wanted to talk through a couple of different scenarios. These are scenarios that we have actually seen in real life with clients calling for our advice about off-duty conduct. And we'll kind of just talk through them here from all of the perspectives that we've presented today: state law, NLRA, and Title VII. Next slide, please. So here's our first scenario. An employee named Mary goes to HR and she reports that her coworker, David, was on his public X account and was retweeting offensive content, including a call for parents to ban Disney because of content that is LGBTQ friendly. Mary herself is gay. She tells HR that she does not feel safe working with David now, that she knows that he has views that she thinks are misogynistic and otherwise offensive. So, I would say that this is a scenario that we see regularly with slightly differing facts. And Scott, do you want to start from a kind of state law perspective? Oh, you're on mute.
Apologies. Every state's going to be a little bit different, right? So like in Connecticut, which is the only state which has a law which says that the First Amendment is applicable to private entities, this might be problematic in Connecticut because you're really an employer regulating someone's speech off duty. In California, this could be problematic because a court could construe his calls for parents to ban Disney because of content that is LGBTQ friendly as a political affiliation or some kind of a political action that's happening off duty. Now, I don't think that a court would actually hold that way in California, but based on the plain language of the statute, right, it's going to be, it could be considered a problem in California. But at the end of the day, I think that this probably does come back to a relation to a business necessity because you have coworkers who are telling the employer, right, that they don't feel comfortable, that they are having a hard time doing their own job because of this person's off-duty conduct. So there's an argument that could be made to that. Now, the practicalities of it, which Dawn and Sam, I'm sure, will get into it, this is probably a situation that merits coaching and, and much less discipline than termination. But from a pure statutory basis, right, it could be problematic in California, probably problematic in Connecticut. But in states that don't have any kind of statute regulating this, it probably wouldn't be problematic unless you get into NLRA or Title VII issues.
So from the Title VII perspective, I think this is a perfect example of where we would start by saying, okay, let's make sure we have the facts, right? So we don't want to just go off of what how Mary has characterized the tweets, but to actually go and get, screenshots of them, because it's going to matter what exactly David is saying, right? So you can imagine a range from, a polite, I'm joining this ban, to horrible, homophobic slurs. And that's going to matter a lot in the context of how we decide to handle it. Does it affect the workplace? Yes, because Mary is here complaining. She's gone to HR. She's filed an actual complaint. It's relevant that these are coworkers, and this is not a manager-employee situation, because that's something else that we want to keep an eye on from a Title VII perspective. Does it relate to a protected class? Clearly, yes. Sexual orientation, which is also the complainant's identity. And does it violate a company policy? So that's going to depend on what our policies say. And that would be one of my first questions to the client is kind of, can we make sure we're looking at your handbook? And the words used, because, again, it's going to be very different if we're talking about, offensive slurs versus a purely political statement. And then does it align with company values? That's going to depend on the company's approach, but I would say most companies, most of our clients will have some protection in their policy for, diversity, equity, and inclusion, and LGBTQ rights. And so, for many of our clients, there would be a misalignment with their company values, again, depending on the actual content of the tweet. Sam, do you want to weigh in?
Yes, thanks, Dawn. So from an NLRA perspective, this on its face would not raise any red flags because this person, I guess we're assuming this person doesn't work for Disney. So, they're complaining about another employer and what another employer is doing. So it's, it has nothing to do with this employee, with their actual employer. So there's no NLRA issue. I would say the fact pattern can get murkier though. I had a case or a situation a few months back where a client called because they had a group of there was a group of employees who were very angry at how LGBT friendly the employer was. And so they wanted to actually actively protest the employer's trans inclusive bathroom policies of having, just allowing people to use the bathroom they felt comfortable in. And so that's an example that is concerted activity, right? And then the question is it protected when you're potentially creating a really unsafe space for, in this hypothetical Mary, but in practice, potentially a lot of the workforce who is non-binary or, just doesn't feel safe with this kind of behavior at work. So that's a way where the NLRB issues could come in conflict with some of the protections of Title VII, and it's uncertain. I would say how that would shake out would be very fact specific.
I just wanted to answer a question that I see in the chat, which is a great question, which is what if a religious conservative employee claims that they do not feel safe because of an LGBTQ post or statement in the workplace? Is that also a valid claim? So I know that all of us are fielding questions just like that on a regular basis, particularly right now, in the moment that we're in society. That's what we call at CyFR the cultural flashpoint, and our cultural flashpoints team is regularly fielding these questions. I think that that's a classic example of competing alleged rights, right? So someone who is claiming that their religious identity is in conflict with LGBTQ rights. It's really hard to give a broad answer because it's really going to come down to the specifics of what does the post say, what does the statement say, right? So it's very different. In a lot of these cases, the statement is just something like, we celebrate Pride Month. And people are claiming to have, religious objections to even that content. That's going to be very different than if it's a statement that's, perhaps more provocative or particularly directed at someone's religion. It is something we're seeing a lot more of, and a lot more requests for religious accommodations from to not participate in diversity training or anti-discrimination training or use of coworkers' pronouns, bathroom policies, as Sam said. So increasingly, we're seeing more of those, and also more of them that are ghostwritten by counsel or by political or religious groups who are sort of looking to try to make precedent in this area. So that could be a whole other webinar, but it's a really great question. Next slide, please. So here's our second scenario. Again, this is a real life scenario that we helped a client with. So the company becomes aware that an employee, James, has been filmed tearing down a poster of an Israeli child taken hostage by Hamas. So in this video, he doesn't say anything, but he tears the poster off a lamppost, crumples it into the trash can, looking straight at the camera, and then walks away. The video goes online. It has thousands of views. There's an Instagram account that is called @JewHaters that posts his LinkedIn profile that identifies him as an employee of the company. This is a pretty frequent scenario, actually, or was a couple of months ago during the initial period after October 7th. So coworkers have seen this video and sent it to HR demanding that the company take action. And some concerned business partners who support Israel have reached out to ask for the company's response, and people in the public have tagged the company in posts demanding action. Scott, do you want to start us off with state law implications?
Yeah, to be frank, I don't think there are many state laws that are going to prevent an employer from disciplining this employee if it gets back to them under this specific fact pattern. Now, if it didn't come back to HR and there wasn't the Instagram profile, then there might be more of a problem even in California. But this seems like it's something that falls outside the scope of most statutes and what they prohibit.
And, from a Title VII point of view, again, when Sam and I actually counseled a client on this one together, we started from the point of view of, let's make sure we're investigating. Let's make sure this is actually the person we think it is. Let's, take a look at, the video ourselves, so that we were clear on what the action was. Does it affect the workplace? Yes. Clearly in this case, it's affecting the workplace in quite a few ways, right? There's a coworker who's demanding action. There's public, there's reputational damage. Potentially, there's concerned business partners. It certainly potentially relates to at least a couple of protected classes, including national origin, potentially, religion, potentially. Does it violate a company policy? In this case, the client determined that it did. They did have various policies that they felt that this was violative of. And does it align with company values? And that was a tricky one. And I think that this is a perfect example of what we at Seyfarth call the voice of the client, which is that there is no one right answer to this question. It is not that you must terminate this employee or that you can't terminate this employee. It's really a question of how does the company, how, as a practical matter, how do they go forward with this many people who are upset about this content, and how do they feel that it aligns with their values? And also, I think, there's a concern about where do I draw these lines so that I'm consistent going forward and wanting to be thoughtful about kind of a comprehensive approach as to, so you're not kind of just reacting one-on-one to these eruptions. Sam, anything you want to add to that?
Yeah, so I think from a NLRA issue, or perspective, I think it would be unlikely that an employer who disciplined an employee in this situation would be found to have violated the act. I think, though, there are other fact patterns related to October 7th that are a lot thornier potentially from an NLRA perspective. I mentioned before you've had an upsurge, especially in the tech industry, but also in a lot of other industries where employees are taking a position on October 7th at odds with that of their employer, and they're demanding that their employer change its position. We saw that, for example, when there was the pro-Israel rally a few months ago, and a unionized group of bus drivers refused to take participants from the airport to the rally, even though it was part of their job. That's clearly, they were engaged in concerted activity, whether or not it was protected concerted activity. I think people could differ. And so I think that's one example. Another thing is if someone has in the hiring context, so this would really go back into Title VII, but in the hiring context, if they said they were part of a pro-Palestinian or pro-Israeli organization, and then they were not given an interview or offered the job, they certainly could file a claim that violated Title VII based on national origin, religion, things like that. So those are less straightforward fact patterns where it's not as clearly egregious as this, right? Where you really could see a court agreeing with the applicant or the employee. And again, that's why it's really important when you're doing the voice of the client exercise internally or with outside counsel, that you're really thinking through what are our legally compliant pathways and then ranking those by risk. And it's often a multitude of shades of gray. It's almost never black and white.
Yeah, and it's good for us to mention here that the EEOC's general counsel has indicated that the agency is paying special attention to claims of anti-Semitism and Islamophobia arising out of October 7th. And that they've seen an increase in charges in that space. And so this is, you know, an area of a lot of scrutiny. And so important to be, you know, particularly thoughtful on some of these issues. Relatedly, I see a question in the chat. What about off-duty social media posts like from the river to the sea, which some interpret to be a call for genocide? That is a perfect example of a cultural flashpoint where, you know, you've got at least two groups that view that phrase in entirely different ways. And so I think that's going to be very context specific as to, you know, again, exactly what language that person is using and kind of the facts of how it's being called to your attention and things like that. I don't know if you guys have anything to add on that one.
Yeah, I think that is, you know, one of the most divisive statements because it is interpreted and it can be interpreted in different ways. And so I think that's why it's really critical to go back to the point Don was making at the beginning of this hypo, which is that you don't want to rush to judgment. You want to give employees their rights to explain themselves, you know, you want to do a fulsome investigation, you know, and oftentimes, you know, we're talking from a framework of discipline, but it's important to remember that employers have lots of other tools. And, you know, having sessions where guided sessions where employees can talk about that they feel in pain right now, or they feel suffering, you know, guided programs like that can be helpful ways, not necessarily to get people to see a different or to agree with a different perspective, but at least to understand that different perspectives exist. I'm not saying that's the correct approach here, but it's important to not just think that the only tool in your tool belt is issuing discipline up to and including termination.
I see another question in the chat. There's so many great questions in here, and clearly we're not going to have time to answer all of them. We invite you to, can you go to the next slide, please, Kate? Those are our email addresses. We invite you to email any of us. We're happy to answer questions offline. I did see a question on, does it matter if the social media posts are private and only visible to friends and the employer can't actually find the screenshots without friending the subject? I know that there are a lot of state laws on that question. And so that's going to be an area we really want to make sure that you are aware of the jurisdictional laws in that space before moving forward. That could probably be its own webinar as well. Anything you want to add on that, Scott?
I mean, no, I mean, it really I could be a webinar on each state.
True.
I'm sure you're right.
All right, I think we're at
also
time.
just want to just note real quick, right, is I've talked a lot about whether or not certain conduct violates a statute. And Don spoke a lot to how employers have a number of tools in their toolbox outside of just, you know, disciplining. Well, you know, just because something based on the language doesn't or does violate the statute doesn't mean that employers shouldn't be using those other sort of less drastic tools before getting into it, because that will show a court that you're more reasonable if it does end up getting to that. So I'd be mindful of the fact that you don't have to go to the most drastic scenario each time.
And I think we are at time. So again, email any of us if you would like to pose a question, or if we didn't get to your question today, we will try to respond. And we thank you so much for being here with us today.
Thanks,
Thanks,
everyone.
everyone.